stand by while NCLA cuts through the noise to signal abuse of administrative power. This is Administrative Static with Mark Chenoweth and John Vecchione.
Welcome to Administrative Static. I'm John Vecchione. I'm here as always with Mark Chenoweth. And last week we discussed a motion to dismiss that we had made in the case of FTC versus PPO, our clients who the FTC has accused of a deception claim in selling dietary supplements, mainly vitamin D, vitamin C, that sort of thing. And we talked about Humphrey's executor last week, but there's another big issue in this case. And I think it is becoming a bigger and bigger issue across many different areas of government action. And that is First Amendment rights to say what you think about something. And we've seen in our cases that we talk about with social media, and there was just a Senate hearing on it this week, actually, of the government putting pressure on all these social media companies to take off messages they don't like. And one of them was on COVID, just like the FTC here says that the client saying that vitamin D and C help your body resist viruses, which they do, is somehow deceptive. And so
it's a controversial claim, John.
I know, it's terrible. In any event, so we've seen in these hearings that many legislatures, even when some of the social media people were like, we shouldn't have banned that Hunter Biden stuff, and we made a mistake here or there. And then the questions came in, and it was like, no, you didn't. No, you didn't go back and do it again. So there's a lot of apps. There's not even any shame, it seems, in wanting to stop speech that you don't like, even for government actors. And I think what we're seeing here in this FTC v. PPO case is another example of it, but it raises questions about a couple of doctrines that the judiciary has come up with. And in this case, our client had a product that PPO and she, Margrett Lewis, were thinking of selling called COVID Resist. And they sent a letter to the FTC and they said, what do you think about this? And the FTC sent them back a bewildering letter with lots of stuff in it. And they said, well, I don't know what that means, but I don't think I want to go forward with this.
They don't appear to think very much about it.
So he does. She doesn't go forward with it and never does anything, but she had the product COVID Resist on a website, never sold anything, not any action taken at all. Just here's what I'm thinking of doing. Yeah, here's what I'm thinking of doing. And we get a complaint that is an amended complaint, because at first they said she sold, but they rightfully withdrew that. But
they tucked tail when you when you barked at them.
Yes, but the key thing is the FTC still believes that with no action, the mere speech can be penalized by them, and it's a civil case, but it has sort of badges and incidences of deception, which is fraud. And you have to plead, as strongly as you do for fraud. So what's interesting here, and it's also interesting with commercial speech doctrine, is that for many years, starting, I'd say in the 20s, but even maybe in the 19th century, commercial speech was given less protection than other speeches under the Constitution. And for some reason, particularly in the 20s and the 30s, they said, really, this is to protect just political speech. And obviously that broke away during the 50s and 60s when, all the naked dancing speech cases came in, right? So that's not political speech, but it was found to be protected speech. And so then the Supreme Court
expression, John.
Expression, right? Exactly. I made it dismissive. I sounded a little dismissive with the naked dancing. Yeah, excuse me. But in any event, but I was always like,
some of the billboards were pretty expressive. I know that.
Yeah, exactly. So the thing is here, though, but obviously the First Amendment concerns that came up in the 60s and 70s expanded First Amendment doctrine, and made it more protective of speech. And then you started to see wearing away of the commercial speech doctrine, which I think should really have to go, but there are still parts of it left.
I would disagree with you on that. I think it's dead. But
okay.
but please go ahead. The Ninth Circuit's trying to keep it alive.
Right,
Exactly. It's dead.
Right.
It is dead after the town of Gilbert, in my opinion.
And certainly, but they haven't announced it. Right. It's a matter of whether they announce it. It's just like, we all thought Korematsu was dead for a long time until they announced it. Right. And then they and also I will also say, what's the other one that they had to announce was, the religious liberty case. No one could ever
lemon,
right?
Test,
So the lemon test was the zombie, right? Walking around until it was actually, they got a Van Helsing stake through it eventually. Or got its head. I guess you kill the brain to kill the zombie. I used the wrong undead killer there. But anyway, so
to brush up on your D&D, John.
I do. But in any event, so they're still going with this, but with no action, with no activity, with just saying something about something that induces no purchase or anything like that. It seems to me because of that, those Supreme Court cases, this is completely unallowable. But it's interesting to me that the government is undeterred. They move full steam ahead with no concern one way or another. They say, well, this is just like, we can protect the consumers by keeping them from speech that does not induce action. I don't think that's right. And I also think that
I think expressions hair design means that's you're right about that. I mean, there's a distinction between speech and conduct, and the Supreme Court has said you can't touch the speech.
Right. And so I think that that's what much of this case is about. And there are other things, but those cases, they exist, and there are California cases that we've cited, thinking that I feel the district judges of California look longingly at some Supreme Court cases, but they look with extreme care at the Ninth Circuit, because all the cases go to the Ninth Circuit, but not all the cases go to the Supreme Court. Very, very few. Right. So, but even the Ninth Circuit says that there are strong First Amendment protections for commercial speech, which at least that sounds good, right? So,
yeah, there was a case. Was it City of Berkeley or Oakland, somewhere in that vicinity, where they were trying to put warning labels on, was it billboards? I want to say, and that got shot down.
I can't recall, but I've always thought that the Ninth Circuit was pretty good on a lot of these things. Actually, after the Berkeley free speech movement, it takes a while for the courts to change direction from whatever the zeitgeist was, and so to the extent that these government actors are all saying no more speech protection for you, you're a misinformer, that the courts should be, for a lot of reasons, should be slower to take that up, and I think they have so far. So, but I do find it interesting. Once again, the administrative agencies appear not to care about any of those cases. They don't seem to worry about them one way or another. They just go ahead and say, well, we're gonna charge you with this, and we're gonna make you defend against it. And I think that they're gonna get a brushback pitch here, and I certainly hope they do, because there are many things that you say in commercial speech. Like one of them that I love is the doctrine that since the courts know that salesmen are going to do certain things, they've actually said that there are certain words that are mere puffery, so that they can't induce. When you say something's the greatest, you can say anything's the greatest, because and I think there's a politician who used that word quite frequently who used to be a salesman.
I think he used it hugely.
Exactly. And so you can say this is the greatest tire, or these are the greatest Wheaties, or no, you can't, because that's a trademark. The greatest cereal,
you can
right?
Say better ingredients,
right?
Better
Exactly.
pizza.
Better pizza. So there's all kinds of words that they're so common that the courts have come up with the theory of mere puffery. because they don't want everyone in the world to be a criminal when they haven't made an explicit statement that can be proven true or not true in a quick hearing. They don't want that. So, and I always love the term mere puffery. I don't know if as far as statutory textualism, I don't know if the mere puffery doctrine really ought to be pushed forward, but I think it's very useful given the nature of how people are, and maybe the nature of even when the statutes are passed, people, the lawmakers maybe didn't think of it. So I'm not coming down one way or another on the textualist background of mere puffery, but I think it
has a long pedigree. You can say that for it.
Exactly.
Now that we're looking at the historical bases for everything.
Exactly.
Puffery survives.
Yes, it was not. Oh, yes. These are wonderful. You can say it's wonderful, right? That's another one. It's a wonderful product, and you can't be penalized for that. So
you just can't say it's blueberry juice if it's not blueberry juice.
That's true. And a lot of cases on how much blueberry juice, right? So, because that's an ascertainable fact. And so I think that this case is going to hopefully push forward that idea that commercial speech is not some sort of backwater of speech rights, because really it's speech that Americans engage in more than almost any other except daily conversation. It's a commercial nation.
Especially John. He's big on the mere puffery on a daily basis.
That's true. Only we're not allowed to say brand names, I guess. But as you know, there is a diet soda or pop that I have extolled extensively for a long time. But in any event,
I just meant John always has the best cake.
All right, we'll be back in a little bit.
Welcome back to Administrative Static. We filed an amicus brief this week in the U.S. Court of Appeals for the Ninth Circuit in a pair of consolidated cases, McDonald v. Lawson and Couris v. Lawson. McDonald v. Lawson is up from the Central District of California. Couris v. Lawson is up from the Southern District of California. And these are two cases. The McDonald case lost below, and the Couris case was stayed after the McDonald case was appealed to the Ninth Circuit. And Couris then appealed, saying to the Ninth Circuit essentially, hey, our case is stayed and we want to challenge that. So they're now up on appeal at the Ninth Circuit. These cases are similar to the Høeg case that NCLA has brought against Governor Newsom. These plaintiffs chose to sue. I think Christina Lawson is maybe the head of relevant agency in California. But in any event, the issues in the case are similar to the issues in our Høeg case, and that is whether or not AB 2098 violates the First Amendment and whether it violates 14th Amendment due process of law. And as I say, the McDonald case coming up from the Central District lost below, and that means that the judge in that case found that the law did not violate the First Amendment. And we filed an amicus brief to explain why our judge, Judge Shubb in the Eastern District of California, who you may recall when Janine Eunice was with us recently, Judge Shubb ruled in our favor and preliminarily enjoined AB 2098. So what did Judge Shubb get right that these other judges got wrong or have failed to reach so far? Well, the district court's holding in the Central District of California was that the plaintiffs were unlikely to succeed on the merits of their First Amendment claim, because he said, he said that, and I think that it was based on a misunderstanding of the prevailing case law, because what the prevailing case law says is that laws that discriminate based on viewpoint, that punish certain expression of certain ideas or opinions, are presumptively unconstitutional. And we've seen that in the Mattal v. Tam case from the Supreme Court, which was the case about the slants ban. We've seen that going back to Rosenberger on viewpoint discrimination being a particularly egregious form of content discrimination. And yet, and so when you look at the, I think both the text and the legislative history of AB 2098, it's pretty easy to see that it's a thinly veiled attempt to silence people who disagree with the government's favored view on these COVID-19 issues. And although the final version of the statute was somewhat better than the initial version of the statute, the legislative record really shows an intent on the part of the lawmakers to suppress core political speech and to really use the law in a way that weaponizes it and allows other people to silence doctors such as the McDonald plaintiffs and certainly such as the Høeg plaintiffs. And if you turn to the language of the statute itself, it talks about misinformation and disinformation. The particular thing that we were talking with Jeanine about, and that Judge Shubb focused on, was this standard that is used in the law. There's already a standard under not just California law, but really a standard under every law or under every state's law for standard of care. And so when this statute makes it illegal for doctors to share false information that's contradicted by contemporary scientific consensus contrary to the standard of care, that standard of care part is already part of the law. And so the only thing that got added by the statute is this false information that's contradicted by contemporary scientific consensus. And I think that what the other judges got wrong, and that we're hoping the Ninth Circuit will get right, is that contemporary scientific consensus is not really something. I mean, it's like nailing Jell-O to the wall, John, to try to figure out what contemporary scientific consensus is, particularly on something that's changing so frequently in terms of what the consensus is. I mean, something that the government, the CDC, was saying is true 6 months ago, now they're saying is false, and it was true 6 months before that.
And the other thing is, where is the consensus? Because it used to be doctors, there was consensus in their community. But if you looked at COVID, the consensus of what the CDC, if the consensus is what the government said, our government agencies had a different consensus than the ones in Europe. And the whole idea of scientific community is everywhere, right? And how could it be that the scientific convention in Germany was different from the United States if there really was a consensus?
Well, and that's part of the problem that you've unveiled through some of the social media censorship work you've done, is that there really was an artificially constructed consensus here by work that was done by the government to silence the perspectives of some people who had some very well credentialed scientists who had views that were not keeping with what the government's current view of the science was. But in any event, the other thing that we point to in this brief is that the people who were responsible for getting this bill written and through the legislature had been threatening to use it to revoke the medical licenses of people like our clients, like Dr. Høeg, and also like Dr. McDonald and the other folks represented in this lawsuit from the Central District of California. And if AB 2098 were truly as benign as the government tries to portray it as in its filings with the court, then these physician scolds who are familiar with the law would not think that its enactment would provide them an opportunity to report their fellow physician plaintiffs to disciplinary authorities and strip them of their medical licenses. But they seem to think that it will do that. And for the same reason that they think it will do that, the law is chilling the physicians and keeping them from giving their honest opinion about things. There's also this notion, you were just talking about commercial speech, John. Well, the NIFLA case came up out of the Ninth Circuit and had to do with whether or not you could order folks at certain kinds of family. Well, I guess it was the other way around, right? NIFLA was a non-abortion clinic, a sort of family planning clinic. Could you order people there to share or to give information about abortion options or other kinds of options? And the Supreme Court said, with the Ninth Circuit, I believe it said, yes, you could order that. And then the Supreme Court said, no, you can't order that. The Supreme Court had rejected in so doing the claim that professional speech gets a reduced level of First Amendment protection. And that's one of the things that we think that the lower court got wrong here as well. It seemed to not be sensitive to the fact that there isn't a different category of speech for professionals. So we'll see what the court does with that. The other issue in the case is the 14th Amendment right to due process of law. We believe that the McDonald plaintiffs, like the Høeg plaintiffs, that their 14th Amendment rights were violated because the law is unconstitutionally vague. And this gets back to what John was talking about a minute ago, that whose consensus. And you've got the Medical Board of California here that's comprised half doctors, half non-doctors. Are the doctors the ones who get to decide what the consensus is? Is it the medical board? Is it the attorney general? In practice, John, it would be the prosecutor who brings the charges, right?
And you'd be putting your license on the line in an extremely undeterminist way. It's not like there's a clear line and then you either cross this line or not. So that is the thing. If they tell you can't say that, when the stars are in alignment, if you go and sit under the moon, you'll be cured. This isn't what we're talking about, right?
No, not at all. No, we're talking about something that's far more contested,
right,
than that kind of thing. And Judge Shubb in the Eastern District of California in the Høeg case, he was very sensitive to this point. And I think the great quote from that case, and we block quote this in our brief to the Ninth Circuit, Judge Shubb says, "Who determines whether a consensus exists to begin with? If a consensus does exist, among whom must the consensus exist? For example, practicing physicians or professional organizations or medical researchers or public health officials, or perhaps a combination? In which geographic area must the consensus exist? California or the United States or the world? What level of agreement constitutes a consensus? A plurality, a majority, a supermajority? How recently in time must the consensus have been established to be considered contemporary? And what source or sources should physicians consult to determine what the consensus is at any given time? Perhaps peer-reviewed scientific articles or clinical guidelines from professional organizations or public health recommendations? The statute provides no means of understanding what scientific consensus refers. And that's really the nub of the problem, is there's no way for any one doctor at any point in time to know whether they're violating the statute. Well, what does that lead someone to do? Well, if it's your entire livelihood on the line with your medical license, it leads you to silence yourself so that you don't run the risk.
And you know what it also does? It stops you from saying true information. When I was a plaintiff's attorney, there were these two oral maxillofacial surgeons who found out that bisphosphonates caused jaw death. And they would say this, and everyone would say, no, that's not true. Well, within 6 years, that was the consensus. This type of law would also stop those two doctors, Ruggiero and Marks, from saying what was absolutely true that they had identified.
And there's great examples of that throughout the history of medicine, right? There were doctors who were making the case that ulcers were caused by a bacterial infection. Everybody said, oh, no, that's not right. Well, it turned out that was true, and you can treat it with antibiotics. Or the fact that Reye's syndrome was caused by giving aspirin. That was something that we talked about. So bottom line is we need the judges of the Ninth Circuit to follow what Judge Shubb said in the Eastern District of California. not legislated that in the Southern Central District of California. We'll keep you posted.